This case sent shockwaves through boardrooms worldwide. It made corporate directors sit up and take notice of the fact that being held personally liable for climate failure is not just a risk in theory, it's a potential reality in practice. Brutally, honestly, I am tired. I'm not firing on all cylinders.
So, Paul, you are the lawyer behind our case against Shell's Board of Directors. Can you tell us what the lawsuit was all about?
Well, this claim was about seeking to hold Shell's Board of Directors personally liable for failing to manage the material and the foreseeable risks that are posed to the company by climate change. Shell's board has acknowledged much of that risk, and in fact the court recognised the materiality of that risk in its decision. But what we alleged by this claim was that the board was fundamentally mismanaging that risk to the detriment of the company's shareholders and indeed to the detriment of the planet. We said that the Board of Directors had failed to act in accordance with its legal duties under the English Companies Act to promote the success of the company, including by having regard to the long-term consequences of the decisions that the board takes, and by failing to act with reasonable care, skill and diligence. And we said in particular that it was imperative that the company manage the seismic risks posed to the company by climate change and the energy transition by putting in place a genuinely Paris-aligned strategy.
So what are those risks? Why is Shell at risk from climate change?
So those risks are generally categorised as litigation risks, transition risks and physical risks. And one of the key ones for Shell in terms of the financial risks posed by climate change is the value destruction, essentially, of its fossil fuel assets. Every single energy transition scenario published by the International Energy Agency now forecasts a decline in demand for fossil fuels.
So how are you feeling after that decision?
The decision was deeply disappointing, especially because we felt that the courts didn't really engage with the claim on anything more than a technical, quite procedural level. There's no doubt that climate change poses seismic risk to Shell, and indeed much of that risk is actually acknowledged by Shell's board and by the court in its decision. That means that it's absolutely critical that the risk is being properly managed. Given the importance of the issues at stake for Shell and its shareholders, and indeed for everyone on this planet, and the significant questions of law to be resolved, it is surprising that the court was unwilling to grapple with the substantive content of our claim.
What do you make of how everything went?
Well, I think the judgment raises a number of important questions, in particular whether the courts are actually being too deferential on the question of breach of directors' duties. The decision is certainly not a vindication of Shell's strategy, but the effect of it is ultimately that Shell has been given a free pass. From my perspective, it's a missed opportunity. It's a missed opportunity for our courts to grapple with the enormity of the climate crisis and to interpret directors' legal duties in light of the risks that it presents to companies and shareholder value. It's a missed opportunity for Shell shareholders. And remember, a significant number of those supported this claim, as I said. And it's also another missed opportunity for Shell's directors to change course and to properly prepare the company for the energy transition and the net zero landscape.
So you've told us a bit about what the court said. What does the judgment actually mean in practice?
Well, the crucial point, I think, is that it doesn't really provide directors with any guidance on what the minimum standard for climate risk management looks like. The court acknowledged in its decision that climate risk is material, and it essentially reaffirmed that directors will be given really quite wide discretion. Now, that was always the case, and rightly so, but that discretion must have some limits. We said in this case that those limits were reached because, on the one hand, the directors had set a strategy for the company to become a net zero energy business and to be Paris aligned. But on the other hand, the targets and means that they'd adopted to achieve that strategy simply won't do so. Now, I mean, there's no denying that this is a negative judgment. If it is upheld in the future in similar actions, it sets a really quite high bar for bringing future derivative action. I personally think the decision will age badly. Some of the implications of it, for example, that a legal action of this type can't be brought by an organisation with a parallel policy agenda, or really by anything less than with majority shareholder support. I don't think that those implications can be right.
Do you have any regrets in taking this case? Has it meant anything for climate litigation more widely?
Well, of course, we're disappointed with the judgment and we must respect it. But we stand by our claim in that fundamentally, we don't believe that Shell's board is properly managing the climate risk facing the company. And I do think there was scope to interpret directors' legal duties rather more flexibly than the really quite restrictive technical approach which is adopted by the court. But look, this case sent shockwaves through boardrooms worldwide. It made corporate directors sit up and take notice of the fact that being held personally liable for climate failure is not just a risk in theory, it's a potential reality in practice. And while, of course, the judgment is negative, we know that since bringing this case, boards are engaging with their duty to manage climate risk far more meaningfully than before. As for Shell, its board does unfortunately seem to be going the other way, removing even the fig leaves of its climate risk strategy. But just because we've lost this case, or because Shell says that a majority of shareholders support its strategy, that doesn't mean that climate risk has gone away. And as the energy transition accelerates, that risk will crystallise for the company in ever more frequent and serious ways. Now, that's likely actually to only increase the scrutiny and the potential action from investors, regulators and governments.
So ClientEarth has lost this case. What's next?
We're undeterred by this decision, and we will keep fighting for accountability. It's companies like Shell that are most exposed to climate risk and which have the most to lose from their directors chasing short-term wins over long-term prosperity. Where companies are mismanaging climate risk, it couldn't be more important to hold to account the people steering us further into climate catastrophe.
Did you think this case had any chance of success?
Absolutely. This type of case has been signposted by the legal community and even senior members of the judiciary for some time. Obviously, winning any case of this type is difficult, with several procedural hurdles to clear before the court even considers the merits. And look, this avenue had never before been used to challenge a high-emitting company's energy transition strategy. Our case was a world first. It really did break new ground. So, of course, given the case's novel nature, we did expect that it would bring challenges. But nevertheless, there wasn't any compelling legal or public policy reason why this claim should not have been allowed to proceed. In fact, to the contrary. One of the oft touted advantages of our common law system is its agility and its flexibility in response to the critical issues of our time. The court's decision disregards the really significant support that we received from institutional investors with more than 12 million shares in the company, and all of those agreed that our claim was in their best interests. Unfortunately, it also fails to engage with the detailed evidence that we put before the court on the board's failings. But directors shouldn't be breathing a sigh of relief. Neither climate risk nor litigation arising from it has gone away. In fact, those will only increase in the years to come.